This is Legal Aid with Evans Ufeli. And today we'll be looking at a very important topic that affects virtually each and every one of us. So pay attention as we teach you the basics of law that you'll find very handy in your daily experience. Today we want to look at tenancy. Tenancy, as people move from one location to the other for the purposes of either greener pasture or economic activity, it is important that people must find shelter. And because shelter is one of the basic needs of man, people will rent houses. And when they rent houses, they will develop a relationship between themselves and a landlord. So how do you keep to the law when you rent a house, when you are a tenant in a house? If you want to rent a house, the first thing you must do is to ensure that you like the location and you like the place. And when you cross that threshold, those are the social angle to it. We now come down to the legal angle of it. You ensure that the person who claim to own the house is actually the owner or his agent. Okay, you pay the rent and possession is given to you. The exchange is that you pay the rent and possession is given to you. When you pay the rent, ask for a receipt. It is very important you do that. Ask for a receipt and ask for a tenancy agreement. In the tenancy agreement, your relationship with the landlord is reduced into writing. There you will see the terms of the agreement. In most agreements, you have covenants. The covenants in the agreement are that you will pay the rent and possession will be given to you. And they will spell out the activity you are expected or allowed to do in that house. If it's for residential purposes, there are things you must not do in that house. If it's for commercial purposes, there are also things you must not do in that house. So you must know that when you have the agreement and the receipt, then you are good to go. By law, you now have what you call easement, the right to enjoy quiet possession in that house. The landlord cannot come and intimidate you or come there to disrupt your quiet possession and the easement that is conferred to you by law. But you must know that there are certain conditions that will require that the landlord may want to take you out of the premises or out of the house. One, where you are in arrears of rent, or you have turned the place into a different purpose for which you rented the house for, or you are constituting and creating nuisance, or you have turned the living apartment into a clubhouse, and therefore you have created what we call contravention under the law. Once that is done, the landlord have a right to issue you a notice to quit. Sometimes he could say he wants to use the premise. But what the landlord must do, he must ensure that if he's giving you a notice to quit, if you are a yearly tenant, by law, you have a right of 6 months notice. He must give you 6 months notice. Within that 6 months, it is expected that you look for an alternative accommodation. Now, that 6 months is not free. A lot of people think that 6 months is free for them to just stay without payment. It is not free. Okay? Now, if you are a half-yearly tenant, that's 6 months, you pay your rent every 6 months, you are entitled to 3 months notice to quit. Okay? And if you are a 1 monthly tenant, you are entitled to 1 week notice to quit. Okay, so these are the threshold that you must take note of. Now, when you have violated any of the principles tied to this agreement and a notice to quit has been given to you, the adequate notice to quit, not that when you are a 6 monthly tenant, the landlord will issue you a notice. You are a 1 yearly tenant, that's a yearly tenant, and the landlord is issuing you a 2 months notice to quit. That will not suffice. Okay, we'll take a short break, and when we return, I'll take you to the next level. Welcome back. This This is Legal Aid with Evans Ufele, and today we're talking about tenancy. And we have highlighted some of the basic things you need to know about tenancy and how it affects your relationship with your landlord. Now, this broadcast is for both the tenant and the landlord. The landlord have certain rights by law, and the tenants have certain rights by law. The rights that the tenant have is the right of possession, the right of quiet possession, easement, and the right to make use of the property in the specification for which it was acquired. Those rights are fundamental. Now, the landlord have its own right to, that is the right to carry out inspection with notice. When the landlord wants to carry out inspection, he must give you notice in writing. It is very important. It is his responsibility to keep the house in a tenantable condition, to ensure that all defects in the house are repaired. It is his responsibility to make provision for fundamental issues that's required in that house. Then the tenant must also make sure that he does not deface the house or alter the house, and must keep same under tenantable condition. The right to keep the house under tenantable condition is both of the tenant and the landlord. It's very important that we know this. So for the landlord, if a tenant is in default of rent, or he has breached the agreement, you can issue him a notice to quit. A notice to quit must be done effectively. The kind of tenancy will determine the kind of notice to quit. I've said it before that a yearly tenant is entitled to 6 months notice, a half-yearly tenant is entitled to 3 months notice, and a 1 month tenant is entitled to 1 week notice. Now, once notice to quit is issued to a tenant and he refuses to park, what you need to do is to ensure that you issue him 7 days 7 days notice of owner's intention to recover premises. Do not, under any circumstance, throw out the load of a tenant out of your house as a landlord. Do not. And as a tenant, do not owe your landlord. It creates friction and it creates division and crisis. Sometimes crisis that will lead to, a breakdown of law and order in the environment. So ensure that you pay your rent, and make sure that you keep the house in peaceful and tenantable condition is important. But assuming but not considering you are unable to pay your rent, it is the responsibility of the landlord to give you notice to quit. And when he does that, and you still refuse to pay, he does not have the right to throw your things out. He has to give you what they call 7 days notice of owner's intention to recover premises. After that 7 days expire, he still does not have the right to throw you out. At no circumstance does he have the right to throw you out. If any landlord throws your things out, it's a criminal offense, and it's predicated under Section 44 of the tenancy law. That is for Lagos State. Okay. Once that is done, you can arrest and prosecute the landlord. Okay. So when you refuse to park after the 7 days has expired and the 6 months notice has expired in the case of a yearly tenant, the next thing the landlord will do is to go to court, is to file an action in court to get a court order to evict you. Now, that court order is what is required by that he needs to get you out of the premises. Okay, and in that case, you have to file your defense. You get your lawyer to file a defense for you. The court will ask you when you want to take your plea, when do you want to leave the place, whether you want to leave the place or not, and why, whichever answer you give, they'll ask why. Okay, so you proceed in that until judgment is delivered. If judgment is delivered, the court will give you usually some time to say, oh no, before so day you have to pack out from that. But that is when the landlord have prosecuted the case effectively, has shown that he gave you notice to quit, has shown that he gave you 7 days, and have filed the case properly, and have paid all the statutory fees that is required, and had made sure that the case is well and properly filed, and had entered appearance in court effectively to get that order of court. In a case where a landlord gets a fake order of court or procure any order that is contrary to what the court has issued, then that is another case of fraud. You can bring an action against the landlord to that effect and have him prosecuted to face the law. The closing point on this issue is that as you habit in the house that is not yours, that belongs to a landlord, you must ensure that you live peacefully with your landlord. If you fail to pay and they get a court order against you, the court will come and level execution. And then your load will be taken away from that house to the court premises. And it will remain the court premises until you are able to pay off the debt. Then the landlord would have taken possession and rent the house out to another person. But your property within the court premises will not be released to you until you have paid the requisite judgment sum. And that judgment sum, is statutory. It has to be paid. So we'll stop here for today. In our next show, we'll take on another legal issue. I hope you learned something from this. Thank you.
Enterprise TV, your one-stop shop for news, programs, human angle stories, the economy, sports, and much more. We go the extra mile to bring incredible details to you. So hop on the train now. Enterprise TV, a tradition of truth.